Thank you very much. So, good afternoon, colleagues, ladies and gentlemen. Thank you very much for inviting me. I'm wary of the time. I have 23 minutes, so we will only have 3 minutes for questions, I'm afraid. The good news is that I'm the last speaker. The bad news is I'm still a speaker, so you'll have to bear with me. I will try and make this as quickly as possible in order to gain some time and perhaps have a little bit of time for questions. So if I could get the next slide, we can start. Thank you. So what are the issues for the current execution of judgments of the European Court? This is a radical presentation. This is not your normal way of presenting things. I think we need to go one slide back. It's not the normal judgment that you have. The problem with judgments in Strasbourg, thank you, is because these judgments are enforced only because of political pressure rather than legal mechanisms, and because there is a lack of mechanism to compel the execution, and the applicant is not involved in post-judgment actions, there is a problem. And this problem becomes even bigger if these cases relate to politically sensitive matters. These sensitive matters, for example, in the Achilleas Demetriades line of cases related to the occupation of Turkey of the northern part of Cyprus. And also, if you take the Yugos case, which I'm sure you have heard about, is about a 1.8 billion judgment that is pending against the Russian Federation. So what's my proposed solution for this presentation? My solution is that we try and create a connection between Strasbourg and Brussels via Luxembourg, and try and attach funds that the EU is giving, the EU Commission is giving to states which are respondents in a case. So essentially attaching assets of the European Union, which are meant for the respondent state in order to satisfy the judgment debt from the European Court of Human Rights. It's rather exotic, it's rather radical, but it is the missing link in human rights and in the enforcement of judgments, and I think it's worth having a thought about it. If I could have the next slide, that would allow me to go into the facts of the case I'll be talking about. This is Dr. Ramon. Dr. Ramon is a chiropractor. He has actually a clinic in the northern part of Cyprus since 1974. He cannot use his property. He went to Strasbourg, got a judgment out of Strasbourg for the loss of use of his property under Article 1 of Protocol number 1. He got about €500,000, and now Turkey is not paying the judgment. This is the same in 32 other cases called Achilleas Demetriades group of cases. And so we have a problem where the country says, yes, we went to the court, you got your judgment, but for various reasons, which may or may not be correct, I am not paying. So if we can take the next slide. What is the proposal? Well, the proposal is very simple. It's to go against the European Union, because the European Union has the Commission, which Commission has earmarked money for pre-accession assistance to Turkey. The procedure that one can follow is in Article 1 of Protocol number 7 of the Treaty of the European Union, whereby there is a 3-step procedure. The first one in the national court is to recognize the judgment. The second in Luxembourg is to waive the Commission's immunity. And the third is to go back to the national court and finish off the procedure. So the first step of this procedure is that you go to the Cyprus court. You ask the Cyprus court to issue a garnishee order nisi, that is to say, an order which is conditionally freezing the funds pending the next 2 steps. So essentially, you get an order from the court saying this money is frozen against the Commission, and then you go to the court in Luxembourg and you ask the court to waive the immunity. Assuming that is successful, you then go back to the Cyprus National Courts and you ask for the garnishee order to become absolute and to be enforced. Now, the issue of sovereign immunity is very interesting because the funds are, for the time being, not Turkish funds. They are EU funds, and that's why we need to go against the Commission and waive the immunity in the Court of Justice of the European Union. So if we could move on to the next slide. Let's do the first step. Can a res judicata order arising out of a judgment of the European Court be recognized in the national legal order of a third party? So what sort of animal is this judgment coming out of Strasbourg? It's not a domestic judgment. Is it an international judgment? How do you go about in understanding what it is? And what effect can you give in the domestic legal order of a country? So I'll turn to Cyprus domestic legal basis. Our constitution, Article 169, gives international treaties super legislative status in the domestic legal order. So it has force superior to domestic laws. And I am told that there are similar provisions in the French constitution, in the Bulgarian, and in the Dutch. So it is not something which is unknown. Now, normally, a judgment of the European Court of Human Rights under the Convention, under Article 46, is obviously binding against the respondent. The existentialist question is whether this is only the case. Could judgments of the European Court be binding, possibly erga omnes? Could it have an effect on other countries? Or could it be the case that since this relationship between applicant and respondent, which is created by the judgment, this judgment can then be executed in a third country because every member country has an obligation to secure to everyone within their jurisdiction, that is the convention jurisdiction, the rights under the convention? If we could take the next one, please. So what's the result having applied to Cyprus? Because all this sounds very exotic and theoretical, we actually did it. We applied to the court under the judgment in Strasbourg. The court issued a garnishee order, nisi. We then took that order and subject to the commission's immunity, we then had to apply to the court in Luxembourg to try and waive the commission's immunity. It's interesting that the Cyprus court took jurisdiction, and that is based on two grounds. A, the fact that the property in issue was in Cyprus, and that court had jurisdiction, and B, the applicant, Dr. Ramon, was resident in Cyprus, and that's how we got around the jurisdictional issue, and we had enough of a connection in order to do that. So if we can move on to the next slide. I'm glad to inform you we passed the half point level here, so we're only going downhill now. So what's the test? How does one waive the immunity? There is an obscure procedure before the court. That's not the general court, that's the ordinary court where an application is made. And under the protocol of the convention, under Article 1 of Protocol number 7, the Commission's immunity will not be waived if the garnishee order is likely is likely in view of the effects which it has under the applicable national model, interfere with the proper functioning and independence of the European Union. Now, to authorize a garnishee order in this case, if that would result in appropriating funds expressly intended by the community for the development cooperation policy or for special interests which are foreign to that policy, then you'd manage to do it. That was the case law we had. We had the Antipas judgment, which we were hopeful that we would be able to use as a precedent in order to bring about the execution. So if we could take the next step, the next slide, please.